Hello, everyone. Jackie here, Jackie Broman for TBA Law. But join Jackie on Mondays. Sorry, I'm a bit late today. Wet morning, a couple of early appointments that I usually wouldn't have on a Monday. So Monday scramble, which is not usually the case, but I'm here now. So today's topic is around de factos and how we consider de factos when we're doing estate planning, and potentially what rights de factos have after someone passes away. So it's been nearly over 10 years now since there's been updates in the law in Victoria and other states in Australia which recognise de facto relationships pretty much on par with marriages, particularly for family law reasons in terms of separations and property splits and children. And so that has transferred to estate planning as well. But before I get to that point, a will is invalid if you get married. So what we do for couples who are in a de facto relationship who could be married is put a clause in the will to say the will's being prepared in contemplation of marriage, so the will is not invalidated if they do get married, so that they can provide for each other and not have to worry about redoing their will later. Now, if someone does pass away without a will, de facto relationships are recognised, but to be a de facto, there has to be a 2-year relationship or there has to be children. Same thing if someone has passed away and a de facto wants to make a claim on the will, saying that they haven't been provided for sufficiently. It has to be a relationship of 2 or more years, and or there has to be children, which sort of brings the relationship on for further faster. So those are some of the technicalities around marriage and how we deal with that for de factos, and then also what a de facto can do if there is no will or if the will is old and doesn't provide for them sufficiently. So if the relationship started after someone had done a will significant time ago and they never updated their will, de facto certainly has the right to make a claim. So our obligation morally to take care of the person that we're in a relationship with is usually our highest obligation. And it does, of course, depend a little bit on the length of the relationship. So again, we're thinking about potentially blended family situations. So if this is a couple that's come together after previous marriages and they've got children to their first marriages and they're not getting remarried, but they're a de facto, yes, you do have some obligation to your children, potentially adult children, not so much, but if they're still minors to your first marriage. But the primary obligation in our lives is often to our partner or spouse. So as soon as someone becomes a de facto, we do have an obligation to provide for them. Then it just becomes, well, what's the level of obligation? And the longer we're with someone, the greater it becomes. And the courts have said that our obligation to our spouse is to provide accommodation and a nest egg. So do think about that in terms of de facto relationships. If it is, for example, a first relationship for people who are, in their 20s, and they're living together with someone for the first time and it goes over a 2-year period, then yes, there's still the main obligation to that person in their lives, and not to leave everything to their parents, but to actually think and provide for that person. So that young person in a de facto relationship who wasn't provided for would have a claim on a will, yes. So those are some factors in dealing with de factos, but otherwise, all the same things apply to de factos when thinking about blended families in terms of weighing obligations between spouses and children and how to provide for those obligations from different assets. So you can go back and have a look at a couple of videos that I've done previously for estate planning and blended families. Those will be saved on the Facebook page. So I hope that that clarifies a couple of things, that de factos have pretty much equal rights as a married spouse, so long as they get over that threshold to be a de facto, the 2 years. That if it's a de facto relationship that could lead to a marriage, we do a contemplation of marriage clause in the will, so the will doesn't become invalid after they get married, same person. Your obligation as well to look after your spouse does also apply to a de facto. So do think about those things when you're in a relationship. There is also a way of recording a relationship that's a de facto relationship if you don't want to get married. So for those who have an objection to marriage generally, there is a way of registering your relationship so that it's recognised legally, so that then there's absolutely no doubt. So you can do that too, in case there's any controversy between, again, adult children from former relationships. Otherwise, if you have any more questions around de factos with estate planning, please, contact us via direct message through the page. You can message TBA Law, or if you check on the About bit, there is our website there. From our website, go to the Meet the Team page. All our individual emails are there, so you can contact us about this topic or any others. If there is another topic you'd like to request, please, by all means, let me know. I will announce topics on the weekend prior to the Monday, so you know what's coming up. If this is useful for anyone you know, please tag their name in the comments so that they see it, or you can share it with them privately on Messenger. While this is live now, it is saved onto the page, as are all our other videos. There are hundreds there. It's a good first resource if you're facing a legal challenge. So head over to the tab on our Facebook page for the videos, and you can see those there. Phone number is available, and the admin email address is admin@tbalaw.com.au. So have a great week, and I'll see you again next week.